Hello everyone, welcome back to the channel EduTap. I am Arshdeep Kaur and I am back with another video on the Contract Act. We have already done some important provisions in video 1 and video 2 on the Contract Act, and this is going to be the last video on the contract, right? So we will be covering some more important provisions and we will be dealing them in the form of MCQs. So let's begin. Before I start, I would like to tell you that EduTap has come up with test series for both the phases, phase 1 and phase 2. It will include chapter-wise tests, sectional tests and full-length tests. We have also come up with a live crash course for both the phases, phase 1 and phase 2. It includes live classes and it includes more than 60 live classes, 2 hours each. It also includes the test series I have just mentioned, and you also get one-on-one mentor support. We are running a limited period time offer, so if you want to avail it, please refer to the link in the description below. Let's begin with our class. Question number 1. As a general principle of law of contract, which one of the following is not an essential for a valid contract? Writing, competency to contract, lawful consideration and lawful object, or free consent. So the answer is writing. It is not an essential element. It does not say anywhere that that a contract has to be in writing only, right? So let's read it. It is given in section 10, and section 10 is very important. Where we talk about a contract, section 10 is the most important because it tells us that what is a valid contract, and we have to start from here, that what is a valid contract, and everything else comes later on. So section 10, it becomes the basis. It is the most important section in this act. All agreements are contracts if they are made by the free consent of the parties. First of all, it must be made by the free consent of the parties. So the consent that they are giving, it must be free. Competent to contract. So the second condition is that the parties that are entering into a contract, they must be competent, right? So what is competent? So that means that they have attained the age of 18. They have attained the age of 18 years, number first, and number second, that they must be of sound mind. So if both these conditions are fulfilled, that means they are competent to contract. For a lawful consideration and with a lawful object. Again, it should be a lawful consideration and it should be for a lawful object, right? So the object plus the consideration both should be lawful and are not hereby expressly declared to be void. So hereby declared means that they should not have been, that it should not have been declared here. That means in this act, it should not have been declared void in this act. Right? So all agreements and contracts, if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Question number 2. Where both the parties are under mistake as to the matter of fact, the agreement will be. So here they are talking about both the parties. It is not a unilateral mistake. It is a mistake which is believed by both the parties. So in that case, the agreement is going to be void, right? So let's read it. It is section 20. Where both the parties to an agreement are under a mistake as to the matter of fact essential, right? So they both are mistaken and it is as to the matter of fact. To the agreement is void. An erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed as a mistake as a matter of fact. So if they are mistaken about the value of the subject matter, right, so it does not form a mistake here, right? So what it says is an erroneous opinion as to the value of the thing. So they were mistaken about the value of the thing. So an erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed as mistake as to be matter of fact. Illustration: A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods have been lost. So here the goods have been lost and none of the parties knew this. So this is mistake. This is a mistake of fact for both the parties, right? From both the parties. So that is why it is going to be void. So neither party was aware of the fact and the agreement is what? The agreement is going to be void. Question number 3. The criteria for who may be an agent is provided in. So there is a criteria that who can be an agent. It means that not anyone can be an agent, but there is some criteria mentioned. And which section is that? It is section 184. Let's read it. And As between the principal and the third person, any person may become an agent. So the general principle is that any person can become an agent, but no person who is not of the age of majority and sound mind can become an agent. So there are two conditions. First, that he has attained the age of 18. He must have attained the age of 18 years. And second, that he is of sound minds. If both these conditions are fulfilled, then he can be an agent, so as to be responsible for his principal according to the provisions in that behalf herein contained. So in order to become an agent, he must be 18 and plus he must be of sound mind. Question number 4. A bailment is the, so what is bailment? It is the delivery of goods by one person to another for some purpose. It is delivery of goods by one person to another for some purpose. There is some purpose that you are delivering your goods to someone, so that is what, that is bailment. Let's read the section first. A bailment is delivery of goods by one person to another for some purpose. So there is going to be a purpose, right? And upon a contract that they shall, wherever the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering it. So you are delivering your goods to someone and there is a purpose, right? You are delivering your goods for some purpose, and that purpose, when it's accomplished, either he is going to return it according to your directions or he is going to dispose it according to your directions again. So whatever you direct him, he is going to do that after that purpose has been solved. For example, when you go to a dry cleaning shop, right, you give your clothes, and what is the purpose? Your purpose is that your clothes have to be dry cleaned. When the clothes are dry cleaned, then the purpose is fulfilled, the purpose is accomplished, and the dry cleaner is going to return your goods, right? So this is what, this is bailment. The person delivering the goods is called the bailer. So in this example, you are going to be termed as what? You are going to be termed as the bailer, and the person to whom they are delivered is called a bailee. And the dry cleaner in this example, he is going to be what? He is going to be termed as bailee. There's also an explanation to this. So if a person already in possession of the goods of another contracts to hold them as a bailee, he thereby becomes a bailee and the owner becomes the bailer of such goods, although they may not have been delivered by the way of bailment. So that means that physical delivery is not important for the contract of bailment. They might not have been delivered by the way of bailment, but that contract can turn into a bailment. Question number 5. When the bailer transfers his goods to the bailee for some specific purpose, and if bailee does any act which is against the terms and conditions of which bailer transfers his goods, the bailer has a right to terminate the contract of bailment as per. So it is section number 153, that is option C. Let's read it. A contract of bailment is voidable. So it is going to be voidable at the option of the bailer. If, what is the condition when it can be voidable? The bailee does any act with regard to the goods bailed. With regard to the goods, so the goods that have been bailed, the bailee has done something which is inconsistent to your direction, which is inconsistent to the your direction or your condition, right? So if the bailee does any act with regards to the goods bailed inconsistent with the conditions of the bailment, so the directions that you gave or the bailment conditions, he has been inconsistent with those, so in that case it can be what? It is avoidable at the option of the bailer, right? So a contract of bailment is avoidable at the option of the bailer if the bailee does any act with regards to the goods bailed inconsistent with the conditions of the bailment. A lets to B for hire a horse for his own riding. So the purpose here is riding by himself. B drives the horse in his carriage, but what he is doing is he is breaching that condition, right? So this is at the option of a termination of the bailment. So here A has an option. It is his prerogative that he wants to declare this contract as void. So it is voidable at the option of who? It is voidable at the option of A, right? Question number 6. A sells by auction to B a horse which A knows to be of unsound mind. A says nothing to B about the horse unsoundness. A does. So here the answer is A does, no fraud. Before coming to this illustration, let's just understand this section and then only you can answer this question, right? So we are going to first read the section. Fraud means and includes. Means and includes means it is not an exhaustive definition. It means that fraud can also include other things. It can mean other things as well. So fraud means and includes any of the following acts committed by the party to a contract. Either the party is committing them, or with his connivance, or by his agent, or his agent is doing that, right? With an intention to deceive another party. Their intention is to what? Their intention is to deceive them. Thereto of his agent, or to induce him to enter into a contract. Or what is their intention? Their intention is to induce them to enter into a contract. Now what are those acts? Let's read it. The suggestion as a fact of that which is not true by one who does not believe it to be true. So in simple words, suggesting a false fact. For example, I'm telling you something, right? And I know it and believe it that it is not true. I know that it is false, and still I am suggesting it to you as true. So this is what? This is fraud under the Contract Act. The suggestion as a fact of that which is not true. So in reality it is not true by one who does not believe it to be true, and I do not believe it to be true. Then also if I am suggesting such a fact, then it is fraud. The active concealment of a fact by one having knowledge or belief of the fact. If someone is actively conceiving a fact, so the word here is used active concealment. It does not include passive concealment. What is the example between the two? For example, that you go to a shopkeeper and you say, I want to buy a chair. He brings out a chair and it has a small crack on it, but it is on the surface of it and you can clearly see it, right? And you still buy that. You still buy that chair, and you still buy that chair, right? So now you cannot say that the shopkeeper has done fraud with you. Here the shopkeeper has committed no fraud. Why? Because this was not active concealment. It was on the face of it. You could have seen it. You saw it and you still bought it, right? The shopkeeper had done nothing to hide it. So this is not fraud. But on the other hand, if we say that the shopkeeper had made an attempt to hide it, for example, he had painted it, for example, he had tried to hide it in any other way. So that is what? That is active concealment. And active concealment is fraud, but a passive concealment is not fraud, right? Let's take another example. For example, that I go to a shop and I ask the shopkeeper that I want this certain book, right? I give him the name of the book and he brings out that copy. So I ask him that, is it all right? And he says, yes, this is all right, and I buy it. But when I come home, I find out that 9 to 10 pages are missing. Now, will this be active concealment? Yes. And why is that? Because no reasonably prudent man is going to check every page of that book before buying, right? So I was not supposed to check each and every page of that book. But so that is going to be covered under what? It is going to be covered under active concealment. Because if a reasonably man could examine it and could find out it easily, then it is not active concealment. But on the other hand, if the shopkeeper has tried to hide it, right, he has done some act, this is active concealment, then it is going to be what? It is going to be fraud under the Indian Contract Act. Third is a promise made without any intention of performing it. So the third is that you make a promise and you are not willing to perform it. So this is what? This is also fraud. Any other act fitted to deceive. Fitted to deceive is that his intention was to deceive a person and that person got deceived. So this is fitted to deceive. And any such other act or omission as the law specifically declares to be fraudulent. So any act or omission that the law declares to be fraudulent is also what? It is fraud. There is also an explanation. Mere silence as to the fact likely to affect the willingness of a person to enter into a contract is not fraud. So mere silence, the general rule is mere silence is not fraud, right? So if the shopkeeper is keeping silence, mere silence is not fraud unless, but there is an exception. The circumstances of the case are such that regard being had to them, it is the duty of the person keeping the silence to speak. So if it is the duty of the person to speak and then also he is quiet, then it is what? Then it is fraud. And who do we consider has the duty to speak? So we consider the person who we trust, right? So if that person, if there is someone we trust, and for example, that there is a person who I trust, right? And I am buying something from him. Now if he keeps silence about that thing, right, then he is committing fraud. So it is only in the relationships that are based on trust, right? So if it is the duty of the person keeping silence to speak, then only it will be covered under fraud. or unless his silence is in itself equivalent to speech. Or if his silence is equivalent to speech means, for example, I am buying a TV. So I say to the shopkeeper that if you keep quiet, I will consider that this TV, this is fit to buy. And he does not say anything. So in that case, if the TV has some defect, then the shopkeeper has done what? The shopkeeper has defrauded me, right? Let's read the explanation again. Mere silence as to the fact likely to affect the willingness of a person to enter into a contract is not fraud unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping silence to speak. So if it was the duty of the person to speak, then it is going to be what? The mere silence is going to be fraud. Or unless his silence in itself is equivalent to speech. Now let's read the illustration, and now it is going to clear to you. A sells by auction to B a horse which A knows to be unsound. A says nothing to B about the horse unsoundness. This is no fraud. Here A has not committed any fraud. But in the second, B is A's daughter. Now this is a relationship that is based on trust, right? So B is the daughter of A and has just come to age. Here the relation between the parties would make it A's duty to tell B if the horse is sound mind and if he unsound mind. And if he does not say so, then he is committing what? He is committing fraud under the Indian Contract Act. B says to A, if you do not deny, I shall assume that the horse is sound mind. So now if he is directly asking, so I shall assume that the horse is sound mind if you don't deny it, and he still keeps silence. If he keeps silence in this case, then what? Then he is defrauding. B says to A, if you do not deny it, I shall assume that the horse is sound mind. A says nothing. Here A silence is equivalent to speech. And what does that mean? That he has committed fraud, right? So this is all about section 17, right? This is an important section and that is why we have read the entire section. Moving on, question number 7. If goods mixed by bailee cannot be separated, then the bailee has to compensate to the bailer as per. So which section is that? It is section 157. It is given in section 157. If the bailee without consent of the bailer mixes the goods of the bailer with his own in such a manner it is impossible to separate the goods bailed from the other goods and deliver them back to the bailer, is entitled to be compensated by the bailee for the loss of goods. So what is happening here is that the bailee is mixing his own goods with the bailer's goods, and he is mixing them in such a manner that they cannot be separated. So in that case, the bailee is so in that case, what has to bailee do? The bailee has to compensate the bailer, right? There is an illustration. Let's read it. A bails a barrel of Cape flour worth rupees 45 to B. B without A's consent mixes the flour with country flour of his own worth only rupees 25. B must compensate A for the loss of flour, right? So here what happens is that you cannot separate two types of flours, right? You cannot separate that. So what does the bailee has to do now? So the bailee has to compensate the bailer because you cannot separate these two things. You cannot separate the Cape flour from the country flour. You cannot take them out. So that is why what? That is why he has to compensate the bailer. Question number 8. Which provision of the Indian Contract Act defines pledge, pawner and pawnee? So the answer to this is section 172. So pledge, what is pledge? Pledge is also a kind of bailment. But in that case, you are pledging your goods for a security. For a security for what? For a security of a debt, right? For example, let's read it. The bailment of goods as security for payment of a debt. So it is a kind of bailment only. Bailment of goods as security for the payment of debt. You are pledging your goods for security or performance of a promise, or it could be for a performance of a promise as well, is called pledge. And the bailer in this case, so the someone who is delivering the goods, he is in this case is known as pawner, and someone who is receiving it, he is known as pawnee. So the bailer here becomes pawner and the bailee here becomes pawnee, right? Question number 9. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract, he is bound to restore it or to make compensation for it to the person from who whom he has received it, right? So what he has to do, he has to repay it, he has to restore it, or he has to compensate it, right? First, let's read it. When an agreement is discovered to be void, so it is discovered later on that it is void, or when the contract becomes void, or due to some reason it has now become void. So any person who has received any advantage under such agreement of contract is bound to restore it. So what he has to do now, he has to restore it or to make the compensation for it to the person from who he receives it. He has to compensate him or he has to restore it. There's an illustration. A pays B 1,000 rupees in consideration of B's promising to marry C. Right? So he has paid rupees 1,000. But what happens is C is dead at the time of the promise. But they didn't know, but C is dead at the time of promise. The agreement is void, and now what? B has to pay A back his 1,000 rupees, right? Because it is void, the contract now it cannot be enforced, it cannot be carried out. So that is why it is void. And what he has done, he has received an advantage. From who? He has received an advantage from A. So now B must pay back his money. B must pay 1,000 rupees back to A, right? Question number 10. The term agent and principal, it is defined in section 182. Who is an agent? Who is a principal? An agent is a person employed to do any act for another or to represent another in dealings with the third person, either for representing him or doing some act, right? For representation or doing an act. The person for whom such act is done or who is so represented is called the principal. So someone who is employing an agent, he is termed as principal, and someone who is being employed, he is known as agent. So agent and principal, this is the relationship of agency, and anything that the agent does in the course of his business, the principal here is going to be liable for his acts, right? So this is the relationship of agency. For example, A employs B as his agent and he tells him that you have to look after all the bank transactions, right? So in this case, A is the principal and B is what? B is the agent, because he has to do something for the principal, that is the A in that case, right? Question number 11. Chapter 10 of the Indian Contract Act deals with, so it deals with what? It deals with the agency chapter. So Chapter 10 of the Indian Contract Act 1872 deals with the laws relating to agency. Contract of indemnity is defined in section 124. A contract by which one party promises to save the other party from loss caused by the conduct of the promiser himself or by the conduct of the third person or another person, right? So what happens in the contract of indemnity is that one person, the promiser, he promises that I am going to cover any losses. I am going to cover those losses for you, either from the loss that is caused due to the promiser himself or due to a third party, right? So this is known as what? This is known as a contract of indemnity, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. A contracts to indemnify B against the consequences of any proceedings which C may take against B in respect a sum of 200 rupees. This is a contract of indemnity. So here A is contracted that I am going to cover for any proceedings that C initiates against you. Against who? Against B. So this is what? This is a contract of indemnity. Question 13. A tender in a newspaper. So a tender in a newspaper is what? It is an invitation to offer. In the previous lecture, we have done that what is proposal, what is offer, right? Proposal and offer means the same thing. And in Indian Contract Act, the term only used is proposal. Nowhere it mentions the term offer. But here they are talking about a tender in newspaper. So a tender in a newspaper is an invitation to offer, right? Let's read it first. An invitation to offer will turn into a contract only when an offer is made by the buyer to the seller. Only when an offer is made. The difference there too lies in the word invitation. It is an invitation to any potential buyer. So we are doing what? We are inviting the potential buyers to make an offer. It is an invitation to any potential buyer to make an offer on the goods sold. For example, I give an advertisement in the newspaper that I want to sell my car, for example, right? So this is what this is, invitation to offer. Now anyone who is going to be interested, anyone who is going to be a potential buyer is going to contact me, right? So for example, A contacts me and he says that I want to buy a car for example 2 lakh rupees, right? And now if I say yes to that, if I say yes to his offer, he has made me an offer, and if I say yes to it, then it is going to turn into what? It is going to turn into a promise, right? There are several examples of invitation to offer: auctioneering, display of goods in a shop, an invitation to tender, display of the menu of a restaurant, advertisement in a newspaper, an invitation to see an apartment for sale, rent, recruitment offers, request of proposals, etc. Right? I hope this is clear to you. Question number 14. As per section 162, a gratuitous bailment is terminated by the death of the bailee, by the death of the bailer, or when the goods bailed are destroyed. So first of all, what is gratuitous bailment? Gratuitous bailment is a type of bailment which does not include any consideration, right? For example, you lending your bike to your friend for him riding, or you lending your book to your friend, and what is the purpose? The purpose is him reading. So this is what this is, gratuitous bailment, because you are not going to receive any consideration for the same. So this is what this is, gratuitous bailment, and it is terminated by what? It is terminated by the death of either party, either the bailer or the bailee. Let's read it. A gratuitous bailment is terminated by the death either of the bailer or the bailee. So it is terminated either by the death of the bailer or by the death of the bailee. Now, question for achievers. Section 178A of the Contract Act deals with what? Pledge by person in possession under voidable contract, pledge by mercantile agent, pawnee's right where pawners make default, defaulting pawner's right to redeem. So you have to comment the right answer below. I hope this was a helpful session for you. For more such videos, please like, share and subscribe to the channel EduTap. Thank you.